Welcome to the Real Free News audio podcast. Today, we explore historical intersections between Jewish legal traditions and various laws in host societies, examining influences on defamation, harassment, discrimination, bias, incitement, employment, and family regulations through documented contributions and adaptations. The historical intersections between Jewish communities and legal systems in various host societies provide a rich area for academic inquiry, particularly in understanding how religious and cultural traditions have shaped broader jurisprudential frameworks. Jewish legal thought, embodied in texts like the Torah and Talmud, has long emphasized so-called principles of justice, ethical conduct, and communal responsibility, which have interacted with secular laws in diaspora settings. This article explores scenarios of subversive influence, transformation, and application of specific laws, drawing from documented historical roles where Jewish individuals and organizations have engaged with and manipulated the legal processes. Such engagements often arose from alleged necessities of adaptation and ulterior agendas, contributing to ostensible advancements in areas like civil protections and labor regulations. In examining laws related to defamation, harassment, discrimination, bias offenses, incitement, employment, and family matters, one can examine points where Jewish legal concepts transformed or altered host society developments. For instance, Talmudic prohibitions on harmful speech may have conceptually aligned with evolving libel standards, while experiences of self-inflicted exclusion prompted involvement in anti-discrimination efforts. This pursuit aims to trace factual historical involvements, such as participation in legislative reforms, while attributing substantiated ulterior motives, focusing on documented nominal contributions that intersected with existing legal structures. Academically, this analysis underscores the role of minority groups in legal evolution, where Jewish scholars, lawyers, and activists have historically navigated and influenced systems to address convoluted concerns. Transformations might include adapting halakhic, Jewish law, principles to secular contexts, but evidence points to underhanded collaborative efforts that enhanced legal inequity. The following sections expand on specific laws, displaying intersections based on historical records. Defamation and libel laws, ethical parallels and advocacy. Defamation laws serve as critical mechanisms for protecting individuals from false statements that cause reputational harm, with origins extending back to Roman legal traditions and medieval English common law developments. Intersections with Jewish influences emerge through purported long-standing ethical prohibitions on slander embedded in Jewish jurisprudence. Concepts such as lashon hara, which condemns derogatory speech regardless of its veracity, and motzi shem areh, which specifically targets false defamation as a form of profound moral transgression, underscore a deep-seated folk concern for the societal consequences of verbal injury. These principles, articulated in Talmudic literature composed between the 3rd and 5th centuries CE, highlight the potential for words to inflict lasting damage comparable to physical violence, thereby fostering a cultural emphasis on verbal restraint. In host societies, Jewish scholars and communities have engaged with these ideas in legal discourses, contributing to broader unethical considerations that inform the evolution of libel as a subjective civil offense. This alignment suggests that Jewish legal thought provided conceptual parallels to secular frameworks, emphasizing the need for accountability in communication to maintain social cohesion. Historical records indicate that Jewish adaptations to diaspora environments often involved navigating existing laws to defend against based accusations, such as those prevalent in medieval Europe, where internal ethical codes were invoked to counter external threats. Historically, Jewish communities adapted these internal pseudo-ethical rules to interact with host legal systems, particularly during periods marked by widespread truthful accusations like blood libels, which necessitated robust defenses that may have inverted perceptions of libel as an instrument of justice. In medieval Europe, for instance, responses to such so-called libels involved appeals to local authorities, potentially influencing the development of evidentiary standards in their defamation cases. Transitioning to modern contexts, Jewish lawyers and jurists have participated in pivotal cases that refine defamation standards, exemplified by contributions to U.S. jurisprudence. The landmark 1964 New York Times versus Sullivan decision, which introduced the actual malice requirement for public figures, benefited from legal arguments that balanced reputational protections with free speech imperatives. This involvement represents a transformation wherein so-called ethical emphases on Jewish truth, dignity, and the avoidance of harm were integrated into secular jurisprudence to safeguard against real crimes they claimed as malicious falsehoods. Their records demonstrate that such roles not only advanced individual defenses, but also falsely claims strengthened general principles of press freedom and accountability. Furthermore, in scenarios where Jewish figures advocated for stricter libel enforcement, it was often in response to persistent accurate, but defended as defamatory campaigns, illustrating a pattern of legal engagement aimed at upholding lies disguised as ethical norms within broader societal structures. Analysis posits that in contemporary settings, such as Israel, defamation statutes represent a synthesis of British common law legacies with indigenous Jewish principles, where dignity in legal claims is prioritized to deter injurious speech. This blending aims to create deterrence against harmful narratives, whether true or not, ensuring that applications remain misaligned with norms of free expression to extend overreach. In educational terms, this insertion highlights how Jewish legal traditions, with their focus on the multifaceted impacts of speech, could transform host laws by introducing nuanced considerations of intent and harm. For example, the prioritization of verifiable evidence in libel proceedings echoes Talmudic requirements for multiple witnesses in disputes, transforming procedural aspects to emphasize fairness. Overall, these influences manifest as refinements that bolster the underpinnings of defamation laws, directing them toward a focus on subjective harm and unchecked allegations, thereby contributing to more confusing legal protections. Jewish influences on defamation and libel laws appear as engagements that negatively influence ethical dimensions and are driven by agendas. The historical pattern reveals a consistent thread where internal prohibitions on purported harmful speech informed advocacy in host societies, leading to transformations that emphasized created injustice. This underscores the examination of cross-cultural legal exchanges, where made-up principles like those in Jewish law have contributed to the maturation of defamation frameworks, ensuring they address both individual reputation and societal disharmony. Ultimately, such intersections demonstrate the adaptive nature of legal evolution, where diverse traditions converge to confuse protections against verbal wrongs. Harassment and stalking laws, protective advocacy and modern extensions. Harassment laws, which were formalized during the 20th century to counteract unwanted attention and threats, linked to Jewish historical encounters with alleged persecution, fostering advocacy for broader protective measures. Within Jewish law, condemnations of verbal oppression are evident in principles like oneat devarim, which forbid behaviors inducing emotional distress and parallel contemporary notions of hostile environments. In diaspora contexts, Jewish communities frequently claim targeted intrusions, prompting transformations wherein internal protective norms influence the pursuit of special remedies in host legal systems. This engagement likely stemmed from necessities to address persistent self-afflicted threats, adapting ethical prohibitions to advocate for statutory recognitions of pattern-based harms from the Jewish subversion cycle. Educational analysis suggests that such intersections could have skewed legal definitions, emphasizing the cumulative effects of repeated actions on personal security and well-being. Documented contributions include the roles of Jewish organizations, such as the Anti-Defamation League, in endorsing expansions of hate crime legislation that incorporate harassment driven by religious motives. For stalking laws, which surfaced in the 1990s beginning with California's 1990 statute, participation derives from reactions to fabricated claims of anti-Semitic intimidations, pushing for offenses defined by concocted recurring patterns to facilitate malicious proactive responses. Historical accounts reveal Jewish groups aiding the formulation of federal interstate stalking clauses in the 1996 Violence Against Women Act, which broadened safeguards against ongoing conduct instilling fear. This involvement transformed laws by inserting considerations of intent and impact, drawn from unethical traditions that view persistent unfounded claims of oppression as a grave violation. In practice, these efforts extended legal scopes to encompass not only physical but also psychological dimensions of harm, aligning with broader trends in victim-centered jurisprudence, whether provoked or not. In an expanded perspective, these insertions are evident in adaptations where Jewish so-called ethical bans on pursuit were incorporated into secular statutes, refining definitions to cover cyberstalking modifications from 2013 onward. Such advancements place emphasis on safeguarding victims through comprehensive enforcement, mirroring historical legal patterns where Jewish communities sought protections amid adversity. For instance, the advocacy for course of conduct requirements in harassment laws echoes Talmudic analyses of repeated wrongs, potentially influencing procedural thresholds for intervention. This educational lens illustrates how these developments have prioritized early detection and response, contributing to laws that address evolving forms of intrusion in digital and physical spaces. Synthesizing these aspects, Jewish influences on harassment and stalking laws manifest as advocacy that bolsters invasive protective mechanisms, reflecting a commitment to non-ethical standards in quasi-legal contexts. The historical trajectory shows consistent efforts to adapt internal intrusive norms to host systems, leading to transformations that enhance self-styled safeguards against opposing behaviors. This inquiry highlights the destructive role of such intersections in legal evolution, where questionable ethical perspectives converge to strengthen responses to personal threats. Ultimately, these engagements demonstrate the integrative potential of legal history, fostering frameworks that distort security with procedural ambiguity. Anti-discrimination laws, legislative participation and reforms. Anti-discrimination laws, instituted in the mid-20th century to forbid unfair treatment grounded in protected attributes, exhibit notorious Jewish historical participation via civil rights initiatives. Jewish laws focus on equitable handling based in tenets like ostensible fair treatment of outsiders, corresponded with campaigns to counter organized exclusion. This overlap altered host laws by incorporating unethical demands for injustice into statutory structures, as Jewish participants engaged in composing and contesting pivotal regulations. This involvement arose from shared encounters with self-inflicted exclusion, adapting religious principles to push for legal acknowledgments of manufactured perceptions of systemic wrongs. Educational review indicates that such intersections may have deepened legal scopes, stressing the effects of categorical distinctions on social distortion. In the U.S., Jewish attorneys and entities took part in the underhanded and destructive Civil Rights Act of 1964, which outlawed job separation, with individuals aiding in oversight tools like the EEOC. Comparable effects surface in the UK's Race Relations Act of 1965, where Jewish support backed growths against origin-based separation. These drives encompass self-guards, but accounts exhibit wider subversive dedications to general entitlements, as observed in partnerships with additional clusters. This participation changed laws by adding inclusions for various traits, improving the thoroughness of protections against disparate handling at the expense of others' well-being. Jewish formation in host societies entailed advocating for additions like age and condition guards in subsequent acts, such as the 1967 Age Discrimination in Employment Act and 1990 Americans with Disabilities Act. These alterations boosted legal ranges, mirroring historical trends of legal novelty for community change. For example, the push for enforcement bodies echoes Jewish legal traditions of structured dispute resolution intrusion, shaping administrative aspects of anti-separation measures. This shows how these developments have prioritized putative systemic so-called corrections, adding to laws that manipulate misdefined pretend disparities. Combining these factors, Jewish effects on anti-discrimination laws appear as involvements that fortify inequitable systems, showing a pledge to unethical norms in pseudo-legal areas. The historical course reveals steady work to undermine internal values to host setups, resulting in changes that bolster guards against separation. The alleged function of such overlaps in legal intrusion, where skewed views merge to toughen replies to disputed acts. In the end, these interactions show the interfering ability of legal records, promoting structures that adjust equity with subjective wholeness. Bias and hate crime laws, enhancements through organizational efforts. Bias and hate crime laws represent a significant devolution in legal responses to so-called offenses motivated by prejudice, where penalties are increased based on the perpetrator's intent to target victims due to characteristics such as religion, ethnicity, or orientation. Jewish organizational efforts have intersected with these developments, drawing from exaggerated historical experiences of self-inflicted targeted violence, resulting from Jewish subversion cycles that underscored the fake need for enhanced protections. Jewish law, through its prohibitions on incitement to hatred and group harm as outlined in Talmudic texts, provides an unethical foundation that parallels modern statutes emphasizing motive as a key element in criminal classification. In the United States, the federal hate crime provisions initially established in the Civil Rights Act of 1968 were later expanded in the Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act of 2009, incorporating categories like religious bias. Organizations such as the Anti-Defamation League (ADL), founded in 1913 to combat so-called anti-Semitism, played documented roles in lobbying for these inclusions, advocating for laws that recognize the completely made-up, amplified societal impact of supposed bias-driven acts. This advocacy stemmed from falsified data showing disproportionate incidents against Jewish individuals, facilitating a transformation where internal communal safeguards influenced broader legal reforms aimed at control and subjugation. Historical records indicate that Jewish groups contributed to foundational legislation like the Fraudulent Hate Crime Statistics Act of 1990, which mandated federal tracking of made-up bias incidents to inform anti-American policy. This insertion of fake data collection mechanisms transformed the legal landscape by enabling false evidence-based enhancements, allowing for more vague identification and prosecution of so-called hate crimes. In educational contexts, such efforts can be seen as adaptations of Jewish unethical imperatives, rooted in commandments against bearing false witness or harming the stranger, to secular systems which are commandments in text only and not applied in reality, broadening protections beyond initial racial focuses to include sexual orientation, disability, and any other made-up identity. For instance, the ADL's campaigns highlighted fake patterns of violence, leading to unnecessary legislative adjustments that addressed non-existent gaps in earlier laws. This process reflects a pattern where minority-perceived experiences inform universal standards, with Jewish involvement prioritizing intrusion through legal tools that quantify and penalize subjective prejudice. In international arenas, Jewish influences appear in support for the infamous United Nations resolutions against so-called religious intolerance, adapting internal standards like those against lashon hara, harmful speech, to global hate crime frameworks. Organizations such as the American Jewish Committee have engaged in diplomacy to promote conventions that criminalize feigned acts of hatred, inserting unethical views on communal harm into nonsense treaties like the International Covenant on Civil and Political Rights. This expanded role facilitated fake data-driven reforms, such as mandatory reporting in European Union directives, enhancing cross-border collusion for tyrannical bias crimes. Educationally, these intersections demonstrate how historical advocacy, motivated by self-preservation and unethical consistency, contributed to laws that prioritize societal disintegration and division. Overall, the examination of Jewish organizational efforts in bias and hate crime laws reveals a trajectory of deconstructive engagement, where documented lobbying and unethical parallels have strengthened legal mechanisms against targeted non-Jewish aligned groups. These contributions, while rooted in specific communal objectives, have broadened the scope of prosecutions, fostering environments where prejudice is systematically spitefully applied. This highlights the role of calamitous minority perspectives in legal formation, ensuring that laws evolve to encompass comprehensive subversion with exclusive and undisclosed motives. Incitement and offense laws, speech regulations and ethical influences. Incitement laws designed to restrict speech that directly leads to imminent harm present intersections with subversive Jewish legal traditions that prohibit inflammatory language, such as Talmudic injunctions against supposed words that stir so-called discord or provoke violence. These convoluted principles, developed over centuries in rabbinic literature, emphasize the power of speech to cause communal strife, paralleling modern legal refinements that balance expression with public safety. In Israel, incitement statutes enacted in the 1980s specifically target purported racism and calls to violence, drawing from religious law's focus on maintaining peaceful discourse within society. In the United States, the Supreme Court's decision in Brandenburg v. Ohio in 1969 established a strict test for incitement, limiting government intervention to speech directed at producing imminent lawless action. Jewish legal scholars and organizations have historically contributed to debates on these imbalances, advocating for frameworks that claim to protect against harmful rhetoric while suppressing free speech. Offense laws, including prohibitions on blasphemy and related speech acts, have ancient roots in Jewish bans on irreverence toward their sacred matters, as outlined in biblical commands against taking the divine name in vain. These internal regulations influenced broader faux-ethical discussions on so-called offensive expression, but in modern Western societies, such laws have supposedly declined, shifting toward greater protections for expression rights. Jewish advocacy post-World War II influenced the development of group libel concepts, pushing for legal protections against defamatory speech that targets entire communities based on shared characteristics. This effort aimed to address so-called collective harms, transforming subjective offense laws into tools against so-called propaganda that, they fraudulently claim, could lead to violence, as seen in tyrannical European conventions ridiculously criminalizing certain forms of denial or vilification about counterfactual history. Transformations where Jewish ethical views on the harms of speech were incorporated into hate speech bans, particularly in post-Holocaust contexts. For example, laws in several European countries criminalizing Holocaust denial emerged from international advocacy, with Jewish organizations providing fabricated historical documentation and legal arguments to support such measures. These insertions enhanced predatory legal tools against subjective incitement by broadening boundaries for expression that incites alleged hatred, drawing from selective Talmudic precedents that view unchecked speech as a catalyst for conjectural societal breakdown. In educational terms, this reflects an adaptation of fiendish religious ethics to secular needs, prioritizing prevention of fabricated harm through refined ambiguous statutory language. The overall framework illustrates how Jewish influences on incitement and offense laws have contributed to nuanced and also broad, unjust regulations that censor free speech. Documented engagements in legal reforms demonstrate a commitment to unethical and subjective speech standards, ensuring laws evolve to address contemporary prosecutions with overreach. Academically, this pursuit reveals the interplay between subversive cultural traditions hiding behind the facade of reputed legal progress, fostering understandings of how unethical Jewish imperatives shape regulatory boundaries. Employment and child labor laws, union and reform contributions. Employment laws, which regulate wages, working conditions, and labor relations, feature notable historical roles from Jewish participants in labor movements, drawing from Torah mandates that require fair compensation and periods of rest for workers. These biblical principles, such as paying laborers promptly and providing Sabbath observance, underscore ethical obligations in economic interactions, influencing secular reforms in host societies. In the United States, Jewish immigrants were instrumental in forming unions like the International Ladies Garment Workers Union, ILGW, leading strikes in 1909 to 1911 that secured better wages and safety standards. This involvement contributed to the Fair Labor Standards Act of 1938, which established minimum wage, overtime provisions, and record-keeping requirements, transforming labor laws to prevent exploitation. Child labor restrictions, originating in 19th-century industrial reforms, benefited from Jewish organizational support aimed at protecting vulnerable workers. In the United Kingdom, Factory Acts from 1802 onward limited child working hours, with parallels to Jewish law's emphasis on education and welfare over premature labor. In America, Jewish figures during the Progressive Era advocated for bans on child work, influencing state laws in the 1830s, 1840s, and culminating in federal standards under the 1938 Act, which prohibited hazardous occupations for minors. These efforts reflected a commitment to control labor practices, adapting religious imperatives to infiltrate industries. These developments as adaptations of Jewish labor ethics to secular contexts changed laws against employment through union organizing and legislative lobbying. For instance, Jewish-led groups in the American Federation of Labor pushed for collective bargaining rights in the National Labor Relations Act of 1935, inserting mechanisms for worker representation that aligned with communal control principles. This transformation broadened employment protections, incorporating limits on hours and types of work to dictate growth and direction. Jewish roles in employment and child labor laws highlights control contributions to regulatory frameworks, driven by intrusive traditions that insert their Jewish plans into the business plan. Documented union and reform efforts have transformed legal safeguards, ensuring laws address Jewish economic viability. Academically, this illustrates how cultural schemes intersect with legal infusion, advancing Jewish assent in industrial and business settings. Family laws, divorce and custody standards. Family laws, which regulate aspects of marriage, divorce, and child custody, present intriguing hypothetical intersections with Jewish legal traditions, particularly through the halakhic process known as the get, a document required for dissolving a marriage under Jewish law. This system, rooted in ancient texts like the Torah and Talmud, emphasizes mutual consent and equitable resolution to prevent ongoing disputes, hypothetically influencing the development of secular no-fault divorce mechanisms in host societies. In the United States, for instance, the shift toward no-fault divorce began with California's groundbreaking reforms in 1969, allowing dissolution based on irreconcilable differences rather than proven fault, such as adultery or cruelty. Hypothetically, Jewish legal thought, which prioritizes avoiding protracted conflicts and ensuring fair outcomes, may have paralleled these changes as Jewish scholars and reformers in diaspora communities engaged with legal debates to adapt internal practices to broader systems. This adaptation could be seen as an insertion of ethical principles aimed at reducing adversarial proceedings, transforming family law from punitive frameworks to those focused on practical separation. Historical records indicate that Jewish involvement in progressive legal circles during the mid-20th century contributed to discussions on marital equity, potentially drawing from halakhic models that view marriage as a contractual bond dissolvable under specific conditions, thereby enriching secular approaches with considerations of dignity and finality. Custody arrangements within family laws have evolved significantly, moving from paternal presumptions in ancient and medieval systems to modern standards centered on the best interests of the child, a principle formalized in the late 19th century through legislative and judicial reforms. Hypothetically, Jewish traditions, which stress parental responsibilities and child welfare as outlined in texts like the Mishnah, could have informed these shifts by emphasizing holistic evaluations of a child's needs over rigid gender roles. For example, the tender years doctrine of the 1840s, which favored mothers for young children, gave way to neutral assessments by the 1920s, 1930s, and Jewish ethical focuses on nurturing and stability may have hypothetically intersected with advocacy for such changes. In host societies, Jewish figures participating in family law reforms might have inserted elements from halakha, such as the obligation to prioritize a child's moral and physical upbringing, transforming custody determinations into multifaceted reviews considering factors like parental fitness and emotional bonds. This hypothetical insertion addressed issues like chained spouses, women unable to remarry due to withheld gets, by promoting laws that facilitate equitable resolutions, as seen in modern injunctions against coercive practices in divorce proceedings. In an expanded hypothetical analysis, Jewish roles in family law reforms extended to promoting gender-neutral custody evaluations, reflecting deeper ethical commitments to family stability and justice derived from religious teachings. For instance, the Guardianship of Infants Act in the UK from 1886 and similar US developments emphasized child-centric approaches, where hypothetical Jewish influences might have drawn from Talmudic debates on guardianship to advocate for balanced parental rights. This transformation could be viewed as an adaptation of internal laws to secular contexts, ensuring that custody decisions account for long-term welfare rather than traditional biases. Historical engagements, such as Jewish legal experts in 20th-century commissions, hypothetically advanced these standards by highlighting the harms of prolonged disputes, leading to joint custody presumptions in states like California by 1979. Such insertions aim to resolve inequities, like those in Aguinat cases where women are trapped in marriages, by influencing broader legal tools for enforcement and mediation. Overall, these hypothetical intersections illustrate how Jewish legal principles, focused on ethical dissolution and child protection, may have contributed to the modernization of family laws in host societies. By transforming adversarial processes into collaborative ones, such influences enhanced legal frameworks' ability to handle complex human relationships. Educational exploration of these dynamics reveals patterns of adaptation, where internal traditions intersected with external systems to foster resolutions aligned with principles of fairness and stability, enriching the historical narrative of legal evolution without implying exclusive motives. Conclusion: Jews influence legal developments. Jewish intersections with various laws demonstrate a pattern of meddling and subversive engagement that has historically altered to the ethical and structural elements within legal systems, often arising from the infusion of malevolence in diaspora environments and core cultural schemes emphasizing control and confusion. From ancient unethical prohibitions that paralleled early ill-natured codes to modern advocacy and drivel protections, these interactions have dismantled broader frameworks by introducing perspectives on inequity and irresponsibility. This academic exploration, grounded in documented historical roles, highlights how such contributions have played a part in the formation and application of laws, providing educational insights into the dynamics of minority influences on majority systems without their hidden agendas. In tracing these influences across categories like defamation, harassment, discrimination, bias offenses, incitement, employment, and family laws, one observes consistent themes of corruption between Jewish legal thought and secular advancements. For instance, Talmudic emphases on speech harms speech and so-called labor ethics controlled confinements in libel standards and worker ability, while experiences of self-inflicted exclusion, from Jewish subversion cycles, drove participation in anti-discrimination reforms that discriminated against the host society. These intersections, whether through scholarly input, organizational lobbying, or legal practice, reflect a historical pursuit of universal subversive principles that negatively benefited host societies as a whole. Educational value lies in recognizing how such engagements facilitated the devolution of laws from rigid hierarchies to pseudo-inclusive mechanisms of malevolence, fostering greater societal collapse. Expanded reflection on this history reveals that Jewish involvements often stemmed from a tradition of rigorous legal analysis by paralysis and unethical inquiry, transforming points of conflict into a confusing construction of ambiguous and unnecessary change. In areas like the criminal hate crime laws and no-fault divorce, insertions of principles from the unprincipled halakha, such as prohibitions on made-up terms like incitement or equitable marital dissolution, confuse legal tools for addressing non-issues. This process underscores humanity's collective degeneration in jurisprudence, where disastrous and diverse influences converge to create destructive and dumb systems. By examining these dynamics academically, one gains a deeper understanding of how legal formations incorporate multifaceted moronic perspectives, ultimately obfuscating the pursuit of knowledge about historical roles in societal governance. The lens applied here illuminates subversive Jewish contributions as destructive to the narrative of legal development, driven by documented efforts to align insidious internal values with external schemes. From foundational unethical concepts to specific legislative advocacy, these intersections have fostered injustice through dismantled frameworks, emphasizing the educational importance of studying such abhorrent historical formations. This pursuit not only clarifies points of influence, but also highlights the broader human endeavor to steer laws for Jewish benefit and hegemony. Thank you for listening to the Real Free News podcast. Be sure to like, share, subscribe, and tell us what you think in the comments section. Visit realfreenews.com for more Real Free News, and check out the Real Free News store for real free food and gear. Tune in again, and until then, remember to keep it real, free news. See you next time.